be left to the Prime Minister and Prime Minister alone. There is one more report, my lord, at page 93, Second Administrative Reforms Committee of the Government of India of 2007. And the relevant is at page 95, clause 2.
So this Chief Justice Venkatachalaya committee did not recommend inclusion of Chief Justice.
No, it did not, my lord. But it says leader of opposition of both houses, speaker, and my lord, it's a broad-based. The idea is, my lord, the Prime Minister should not have the complete say. It was, of course, my lord's notice, it was reviewing the working of the Constitution, not for specifically for this purpose. Now, another report I want to refer to your lordships is, my lord, Second Administrative Reforms Committee, which is at page 93. I'm sorry, my lord, I missed one para of the Constituent Assembly debate. I am thankful to my learned friend. Lord, page 57, if a lordship come back, what Dr. Ambedkar has to say, my lord.
Page 57.
Page 57, last para.
Last pair. Now with regard.
Now, with regard to the question of appointment, I must confess that there is a great deal of force in what my friend Professor Saxena, that two-third majority, my lord, said, and there is no use of making tenure of the Election Commission a fixed and secure if there is no provision in the Constitution to prevent, my lord, I find it very difficult, either a fool or a knave or a person who is likely to be under the thumb of the executive. Too strong a word, my lord. My provision, I must admit, does not contain anything to provide against nomination of an unfit person to the post of the Chief Election Commission or other election commissioner. I do want to confess that this is very important question and it has given me a great deal of headache. And I have no doubt that it is going to give this House a great deal of headache. In the USA, they have solved this question by the provision contained in Article 2, Section 2 of their Constitution, whereby certain appointments which are specified in Section 2 of Article 2 cannot be made by the President without the concurrence of this Senate. So far as the power of appointment is concerned, although it is vested in the President, it is subject to a check by the Senate, so that the Senate at any point of time when a particular name is proposed, make inquiries and satisfy itself the person proposed in a proper person. It's very important, my lord. The appointment is very necessary.
Any discussion?
Yes, my lord.
In Chief Justice Venkatachalaya committee report?
Yes, my lord.
As to why they did not accept the earlier report of Dinesh Goswami?
No, there is no reference to that.
There is no.
There is no reference to that, lord. There is no reference.
Just point out, because Justice Venkatachalaya committee was on working of the Constitution. So they were looking at all the provisions of the Constitution.
But the earlier committee is also working of the committee.
Yes.
It's not particularly.
Dinesh Goswami report.
This is also. This is Committee on Electoral Reforms.
Yes, it's electoral.
That was on electoral reforms, my lord. Dinesh Goswami committee was on electoral reform. And when I come to, my lord, the law commissions also, my lord, there are certain things there. Yes, yes. After this, I wanted to invite your lordship's attention to page 93.
Is it so because if the CGI is the member,
Yes.
there could be some inconveniences, some problems?
There cannot be any inconvenience, Lord.
Just asking you whether
Lord, I don't,
anywhere have you.
I have not seen anything, my lord, that anyone has expressed that there will be inconvenience, my lord. In fact, the CGI is a member of the, my lord, Lokpal Appointment Committee. He is a member of the Delhi, the CBI Director Appointment, my lord. Even CBI Director. CBC. Act, because Lokpal Act has amended the Delhi Special Police Act. Section 4A is inserted, saying that the Chief Justice of India will be part of the selection committee. Even a CBI director can be there, my lord, definitely, my lord, election, there is no question of inconvenience. All that we are looking for is an impartiality. We have a face, my lord, who, it's not that you cannot be removed, but who is appointed. That's why your lordship's collegium system, I'll come to those judgments, my lord. We must have faith in the person. And today, my lord, with great amount of respect, I don't want to say any disrespect, but there's slogans which are shouted in public meetings against the Chief Election Commissioner and commissioners, my lord, is
It's a
just a minute, Mr. Solicitor, we don't run away the facts. We do not run away from the facts. Yes, this is a constitution. It has to be seen, my lord. I have never seen, my lord, in a public meeting, Chief Election Commissioner, it pains me, my lord, that election commissioner have been said with words, my lord, which I don't want to utter in this open court. And meeting after meeting, why no action has been taken, my lord? It should have been taken. That party should have been banned, according to me, my lord, for saying so. It's a model breach of model code of conduct.
Some mob goes and, my lord, makes abusive words against the honorable judges. Lord, should we dismantle the collegium system? What is this argument?
Yes. What is this argument? Is the court for to consider? Mr. Solicitor, I am not trying to convince you. I am trying to convince the court only. What I am saying, my lord, with this also, no action is taken. Why should not the action be taken against that party? My lord, may I come to it now on page 93? Page 93 at 95.
We would appreciate
Yes.
that when one senior counsel is addressing us,
Yes, my lord.
no one else should interrupt.
Grateful.
We are extremely grateful.
Yes, precisely.
Where else?
Yeah, we are not going anywhere else.
We are there to check in. If he goes beyond his bounds, we will stop.
He had
Yes.
already, my lord. I'm sorry. He had already.
You know, in course of argument, Mr. Solicitor, you have been also in this profession for so long. Course of making submissions, sometimes you have to go a little here and there.
It is directly on the point, my lord. I'm saying whether we had confidence in a system where we are constitutional fathers thought that. Anyway, page 95, my lord. May I just go to page 95? Appointment of chief. This is by the, my lord, a committee, Second Administrative Reforms Committee, on the report on ethics of governance, etc., by the Government of India. At page 95, para 2.1.5, appointment of Chief Election Commissioner, Election Commissioner. The present procedure of appointment of the Chief Election Commissioner and appointment and the other election is laid down in 24, stipulates that they are to be appointed by the President on the advice of the Prime Minister. Yes. During the debate, page 96, in the Constituent Assembly on the procedure for appointment, there were suggestions that the persons appointed as Chief Election Commissioner should enjoy the confidence of all parties, and therefore his appointment should be confirmed by 2/3 majority of both houses. Even at that stage, there were views that the procedure for appointment should be broad-based one and not confined to one person, my lord. Above all party consideration, in recent times for statutory bodies such as NHRC, CVC, appointment of chairpersons and members are made on the recommendations of broad-based committee. Thus, the appointment of Chief Vigilance Commissioner committee consists of Prime Minister, Home Minister, Leader of Opposition, whereas NHRC committee is chaired by the Prime Minister and its members, Speaker of the House, Home Minister, Leader of Opposition, Lok Sabha, Leader of Opposition in the Rajya Sabha, Deputy Chairman of Rajya Sabha. Given far-reaching importance and critical role of the Election Commission in the working of our democracy, it would certainly be appropriate that a similar collegium is constituted for the selection of, when you say collegium, my lord, it's from different fields. It can't be, my lord, the same person nominates one and then he appoints. Constituted for the selection of the Chief Election Commissioner and the Election Commission. Recommendation, the collegium headed by the Prime Minister, Speaker of the House, Leader of the Opposition of the Lok Sabha, Law Minister, Deputy Chairman of Rajya Sabha as members should be made recommendation as consideration of the President. It's similar to, my lord, Venkatacharya Committee report. Now, what is important is, my lord, Law Commission of India, 255th report, my lord, which starts at page 98. CGI. Two 55th report, my lord, is on electoral reforms again. Page 99, para 6.1. The ECI is an independent constitutional body which has been vested with the powers of superintendence, direction and control of the preparation of electoral roll as the conduct of all parliamentary state elections and the elections of the president, of the vice president, or so and so. 6.3. Article 324(5) of the Constitution intended to ensure the independence of ECI and free from external political interference, and thus expressly provided for the removal of Cji-Sc. Removal is like the Supreme Court judges, my lord. Now the appointment part is, my lord, the recommendation, lordship may kindly come to, my lord, page 101. Recommendation, para B, appointment of election commissioner and Cji-Sc. Appointment process, the first it has been quoted. And now the final recommendation is page 103, para 6.12.1. Recommendation of the Law Commission. Given the importance of maintaining the neutrality of ECI and to shield Cji-Sc and election commissioner from executive interference, it is imperative that the appointment of election commissioner be a consultative process. To this end, Commission adopts.
Point 12.2.
Yes, my lord.
The recommendation is
to
that
12.2.
CGI should be
Yes.
one of.
To this end, the
Yes.
Commission adopts the Goswami Committee with certain modifications. First, the appointment of all election commissioners, including Cji-Sc, should be made by the President in consultation with the three-member collegium or selection committee consisting of Prime Minister, Leader of Opposition, and Chief Justice of India. The committee considers the inclusion of the Prime Minister as important as representative of the current government. So, my lord, this is, and then lordship would kindly find, my lord. So, my lord, lordship would see, my lord, before the making of the constitution, by the various committees, during the debates, and post the constitution, my lord, various committees from time to time have recommended that, my lord, it has to be multi-member committee, so it cannot be at the wishes of a single person, single individual, as the Act has provided. Now, in this light, my lord, the Constitution Bench in the Anoop Baranwal case had dealt with the aspect at a great length, my lord. Would you now, lordship, take it up, my lord, the volume 3. Page 93 of this, because first I have given the two other judgments, Mohinder Singh Gill and T.N. Session. Page 93. Is, my lord, Anoop Baranwal judgment by a Constitution Bench. Opinion delivered by Honorable Justice Joseph, and there is a concurring opinion by Justice Astogi. The judgment starts at page, my lord.
93.
93. The
144.
Start at page 144. And 147. So, just submissions of Mr. Gopal Singh Karnan are noted, my lord. And para 38 are this, lord, which I have read to your lordship, lord. The historical perspective of the committees and the Constituent Assembly debates are there. And para 84 to 86 is important, my lord. Lordship would permit me to read that. Page 183. Iska page is not open. Para 84. It is clear that founding fathers intended that the elections in the country must be under superintendence, direction and control of an independent body. The body is Election Commission of India. Under Article 324, the Constitution, the Chief Election Commissioner is an unalterable feature or figure. A commission can consist of only Chief Election Commission. A multi-member commission was also contemplated by the founding fathers. However, the post of election commissioner was need-based. For nearly 4 decades, there was no election commissioner. As we have noted that on 1989, first 2 election commissioners were appointed. In that regard, the appointment of the chief election commissioner and the election commission, the constitution does not provide any criteria. It does not fix any classification. It does not prescribe any disqualification in the matter of appointment, either as chief election commissioner or election commissioner. The appointees have been bureaucrats drawn from civil services. 324(5) deals with conditions of service. Then para 86. The first proviso to Article 324(5) acts as a guarantee against the removal of the Chief Election Commissioner, except on like ground, a similar manner, a judge of the Supreme Court can be removed. The conditions of service of election commissioners shall not be varied to his disadvantage. This means Parliament cannot, or the government by rules, either remove Chief Election Commissioner except by impeachment in the manner provided for removal of a judge of the Supreme Court, nor the Parliament can make law, nor the government or rule vary conditions of service of Chief Election Commissioner. The proviso to Article 325 operates as a singular insulation to protect the Chief Election Commissioner either from being arbitrarily removed or his conditions of service being varied to it. But as contemplated by the founding fathers, the protection against arbitrary removal or protection against varying conditions of his appointment were not sole safeguard so far as far more vital was the appointment of the right man and the need to take out of the exclusive hands of the executive. But this is what the ratio of the judgment is, my lord. I'm just submitting. And now, Lordship, may kindly come to para 106, my lord, which is page 196. It deals with the cases regarding separation of power and judicial activism. And at para 111, page 197, separation of power has been held to be a basic structure of the Constitution. Page 111, Indira Nehru Gandhi is quoted, the principle of separation of power is not a magic formula for keeping the 3 organs. 112 is important, my lord. Separation of power is understood as prevailing in India, constitutes a part of the basic structure of the Constitution of India. See Keshavan Bharti. Then Indian Aluminium, adjudication of the rights of the party is an essential judicial function. Now, my lord, I will show to your lordship, my lord, the Election Commission exercise varied judicial powers also, my lord. So it has to be an independent person completely. And the appointment process has to be independent. The adjudication of rights of the party is an essential judicial function. The legislature has to lay down the norms and conduct of the rules which will govern the parties, and transactions require the court to give effect. Now, Roman 4, subpara 4 of para 56, courts in their concern and endeavor to preserve judicial power equally must be guarded to maintain the delicate balance devised by the Constitution between 3 sovereign organs functionaries, in order that they know that the rule of law permits to fulfill the constitutional obligations of establishing an egalitarian society, respective sovereign functions, etc., etc. Lordship may skip over that part, my lord. Lordship may kindly come to page 198, para 116. Separation of power is a part of basic structure of the Constitution. Equally, judicial review has been recognized as a form of part of basic structure. Judicial review of a legislation is expressly provided in Article 13. A court, when it declares a law by the legislature unconstitutional, if it be that it is within its bound, cannot be accused of transgressing the principle of separation of power. Declaration of a law made by the Parliament as unconstitutional form part of its power. In view of the enunciation of the doctrine of basic structure in India, unlike perhaps in most countries, even an enactment to the Constitution can be declared as unconstitutional by the court. Such exercise cannot expose the court to the charge that it is not observing the limits of the Constitution. Then Lordship may skip over regarding judicial review. Lordship may kindly come to para 186, my lord. Page 224. para 186. What, my lord, what is important is that the court noted in Anukul that holding free and fair election constitute a basic feature of the constitution and approved of the view apparently that the right to elect is fundamental to the democracy. Even as treated as statutory right, at any rate, cannot be divorced from the or separated from the mandate of 326. The right is of the greatest importance and form the foundation of a free and fair election, which in turn constitutes the right of the people to elect representatives. We would, for the purpose, list the question rest here to process said. Then democracy, my lord, the Dr. Ambedkar's speech is quoted, my lord. I have read to your lordship that, and lordship may kindly come to para 200, my lord, at page 229. Article 324 is a plenary provision clothing the article Constitution Election Commission with the entire responsibility to hold national and state election and carries with it the necessary power to discharge its functions. However, the Law Commission cannot act against a law framed by the Parliament or state legislature. The power of the Commission is also subject to the norms of fairness and it cannot act arbitrarily. The action cannot be mala fide. Article 324 governs in the matters not covered by legislation, being a high constitutional functionary which is expected to function fairly, legally. If he does otherwise, the court can veto the illegal action, say Mohinder Singh Gill. Now, my lord, 201, Election Commission under 324 can postpone election on the basis of the opinion that there exist disturbed conditions by the state, in the state or some area of the state, thus making of holding free and fair election not possible. This court followed Mohinder Singh Gill in democracy depends upon the man as much as the constitution. Election Commission is endowed with the power to recognize political party, to decide disputes arising from them. It can also adjudicate controversies or splinter groups within a political party. The right, this is, my lord, where the judicial power comes, my lord. I'll show to your lordship later. The commission has also been found to have power of issue of symbol order. This right is traced to Article 324. Then, recognizing the magnitude of exercise of control is fair in election, this court declared that in case of conflict of opinion, the opinion between Election Commission and the government, as education of machinery to deal with the state of law and order, assessment of Election Commission was to prima facie prevail. This court no doubt observed that mutually acceptable conditions so and so. While dealing with the power of the Election Commission to the requisite staff for election duty, disagreeing with the commission, it could require the service of the employee of the Bank of India. This court declared the Election Commission did not have untrammeled power. The power must be traced to the Constitution. Election Commission has the power to issue directions to conduct elections, requiring the political party to submit details of the expenses incurred or authorized by them for the purpose of election of their respective candidates. The power was traced to the conduct of election. All the powers of election, though not specifically provided, but necessary for effectively holding elections, are available to the Election Commission. So 324 is the reservoir of power. Now, lordship may kindly come to my lord, para 207. From a spate of violence in the state of Gujarat in the dissolution of assembly, the commission took the view that it will not be possible to hold election, though 174 mandated there shall not be more than 6 months between. After finding that 174 did not apply to the dissolved assembly, it was indeed held that this court reiterated the words that superintendence, direction, and control and conduct of election were the broadest term. This court also found that there are no free and fair election. This is the end of democracy. Now, my lord, this is on the width of the power of the Election Commission. Lord, I have a separate chart, my lord. I'll invite your lordship's attention to that. Would your lordship now kindly come, my lord, para 213. 213. And 214, it's very, very important, my lord. To page 233, para 213. We would therefore find that the Election Commission of India has been charged with the duty and blessed with extraordinary power to hold elections to both Parliament and the state legislature from time to time. This is an enormous task. The power it possesses under Article 324 is plenary. It is only subject to any law made by the Parliament or by the state legislature. Undoubtedly, the Election Commission is duty bound to act in a fair and legal manner. It must observe that the provisions of the Constitution abide by the direction of the court. The same being done, it can draw upon a nearly infinite power of the reservoir power of power. Once a poll is notified, which again can be called to be taken by the Election Commission itself and indeed capable of being misused and subject to considerable controversy if bias, subservience of the power, that is betrayal, it assumed unusual powers. Its writ lies across the government over the length and breadth of the country. Officers of the government who come under it charge become the subject to the superintendence of the commission. The fate of the political parties, its candidates, and therefore the democracy itself, to a great measure, is allowed to rest in the hands of the Election Commission. We may therefore be the officers, while there may be officers who assist the commission, virtually important decisions has to be taken by those at the helm of affairs. It is the Chief Election Commissioner or Election Commission at whose table the buck must stop. It is in this scenario we bear in mind that when a decision is taken in the process of holding the poll, that's subject to proceedings which are initiated in the court, which conduce to the effective holding of the poll, any proceedings which seeks to bring the election process under a shadow of taboo. The significance of this aspect is that it adds to the enormity of powers of the responsive to Election Commission. Awaiting outcome of the poll and to question the Election Commission before the tribunal may result in illegal, unfair and malafide decision of the Election Commission passing under the muster of the day. Once the elections results are out, the matter is largely reduced to a fait accompli. In fact, at many a times, an omission or a delay in taking decision can itself be fatal to the holding of free and fair election. The relief vouched in an election petition may not by itself provide a just solution to the conduct of election in an illegal, malafide or unfair manner. These observations have a direct connect with the question which are concerned, namely the need to take an appointment of the members of the Election Commission out of exclusive hands of the executive, namely the party which are not unnaturally has an interest in perpetuating its power in itself. So that is the question posed, my lord. And lordship would kindly now come to my lord. Para 260, not necessary. That's all that we can go on reading it.
And underlet evil, and underletting abuse, service political day of democracy.
So, Para 220, my lord. Equally, the startling questions which we have described, which must be possessed by the Election Commission, is an indispensable for an unquestionable adherence to the guarantee of equality under Article 14. The wide spectrum of powers the Election Commission exercise them unfairly or illegally, as much as it refuses to exercise power. When such exercise becomes a duty, it has the telling and chilling effect on the fortunes of the political parties. Inequality in the terms of matter of treatment of political parties who are otherwise similarly circumscribed, unquestionably balanced, so and so. Political parties must be viewed as an organization representing the hopes and aspirations of its constituents who are citizens. Lordship may ignore, my lord, this part of it, although. Then Lordship may kindly come to, my lord, that there is a power under the symbol order. And, my lord, Lordship may straight away come to Para 248. 222. Sorry. Yes, I'm so sorry. I missed one para. Para 222. That's right. Page 236, my lord. Para 222. The Election Commission, including Chief Election Commissioner, blessed with infinite power and who are able to abide by the fundamental right, must be chosen by the must be chosen not by the executive exclusively and particularly without any objective yardstick. Lord, this is the ratio of the judgment. They are reiterated in further paragraphs, my lord. So it is very clear, my lord, it cannot be chosen by the executive exclusively and without any objective yardstick. Now, Lordship may kindly come to my lord.
Ansari, just one moment.
Yes.
Please come to 146.
146, my lord. Page 146.
Starting page of the judgment.
Yes, my lord.
Para 3.
Yes, my lord.
I'm
Yeah.
looking at prayer 1
Yes, my lord.
of WP Civil 104.
Yes, my lord. May I read that?
Which was the lead petition.
Yes. Mandamus.
Prayer 1.
Yes.
and you will have to answer.
Yes.
Or you will have to show us from the judgment
Yes, my lord.
why this prayer was not granted.
May I just read
If
the
this prayer
prayer?
had been granted, that would have been the end of the matter.
Please, your lordship. May I just read this, my lord? Issue a writ of mandamus, an appropriate direction or order, directing, commanding the respondent to make a law, ensuring fair and transparent process for selecting by constituting a neutral and independent collegium selection to recommend the name of the appointment of election commissioner of the Constitution of India. What
So if
prayer
you
is,
read
my lord?
this prayer with 222,
Yes, my lord.
why did the court stop at?
Lord, it says it is a neutral and independent collegium selection committee. Neutral, independent collegium.
Once it is said in 222
Please, your lordship, my lord.
that the
It cannot be left.
collegium should not be
Yes,
comprised of persons
yes. Of executive exclusive.
because the election commissioners have to be chosen not by the executive exclusive.
Please, your lordship, my lord.
Right. So why did the court stop?
No, it has gone further, my lord. I'll show to
That you have to show.
I'll
What is the reason? Just show.
Yes, yes, my
that
lord.
paragraph.
Yes, my lord.
You stop.
301.
248.
Yes.
Independence. Independence the meaning actually 248.
Page 245. Concept, independence. Yes. Independence and sterling and indispensable attribute. What the prayer is, my lord, that it must be neutral and independent collegium. That is what is expected, and what the 222 said, it cannot be executive alone. And further discussion is here, my lord. 248 onwards, my lord. I may have, yes, para 248, page 245. Yes. What is independence? Independence is a value which is one of the elements in an amalgam of virtues that a person should possess. The competence of a man is not to be in conflict with fierce independence. A person may be excellent, that is, at his chosen vocation. He may be excellent administrator. He may be honest, but the quality of independence transcends the contours of qualities of professional excellence as to the dictates of the honesty. We may, no doubt, clarify that ordinarily honesty would embrace the quality of courage, of conviction flowing from perception of what is right and what is wrong, irrespective of consequences to the individual. An honest person would ordinarily be unrelenting, take on high and mighty, preserve his righteous path. An election commission is answerable to the nation. The people of the country look forward to him so that the democracy is always preserved and fostered. We may qualify the above observations by stating that true independence of a body of persons is not to be confused with sheer unilateralism. This means that the election commission must act within the constitutional framework and the laws. It cannot transgress the mandate of either and still claim to be independent. Riding on the horse of independence, it cannot act in an unfair manner. Now, independence must be related finally to the question, what is right and what is wrong. A person who is weak need before the powers that it cannot be appointed as an election commission. A person who is in the state of obligation or feels indebted to one who appointed him fails the nation and can have no place in the conduct of election, forming the very foundation of democracy. This is the answer, my lord. But your lordships have laid down the guideline, my lord, that you cannot leave it to the person, my lord, who will appoint him and then he feels obligation for his lifetime and he feels indebted. An independent person cannot be biased, holding scales openly even in the stormiest of times, not being servile to the powerful, but coming to the rescue of the weak and wrong, who is otherwise right, would qualify as true independence. This is the test, my lord, whether we have a system which selects a person who is not obliged to a person. 2251. Upholding the constitutional values which are in fact a part of the basic structure, which includes democracy, rule of law, right of equality, secularism, purity of election, otherwise would indeed proclaim the presence of independence. Independence must embrace the ability to be firm even against the highest. Not unnaturally, uncompromising, fearless will mark an independent person from those who will pull hold by holding their karma. In the context, we feel advised to refer to the following discussion in the AOR Association case, not the 4 judges case. A little personal research would result in revelation that the concept of legitimate power of reciprocity debated by Benin in these articles, the basis of power and power of interaction model of so-and-so influence, in addition to having dealt with the very physiological regions which influence the personality of an individual, reference was also made to the legitimate power of reciprocity. It was pointed out that the reciprocity norm envisages that if someone does something beneficial for another, the recipient would feel an obligation to reciprocate. In view of the view expressed by the author, the inherent indeed of the power is universally available in the subconscious of the individual. On the satisfaction of the achievement of the desired power, there is a similar unconscious desire to reciprocate the power. It is important that the appointment must not be overshadowed by even a perception that the yes men will decide the fate of the democracy, that all it promises. Certainly the darkest apprehension of the founding fathers, as buttressed by the reports and other materials, unrelentingly point to the impression. So Lord, this is what the independence means, my Lord. There should be no reciprocity, there is no obligation, there is no indebtedness. Further, my Lord, this court has further, in more clearer terms, has said in the subsequent paragraphs, which I can just refer to your Lordship, my Lord. Page 263, 263, para 301. Yes. May I read from 299, my Lord? Para 299, page 263. It may be true, my lords, about it, that the Election Commission of India provides its services to certain countries. That, however, does not deflect this court from providing what its founding fathers contemplated and also advocated in various reports. It may be true that the Election Commission of India were appointed for the 4 decades of the Republic and thereafter. Since the year 1993, Election Commission has become a team which consists of Chief Election Commissioner and 2 election commissioners, It may be true in the sense that the President, acting on the advice of the Prime Minister in accordance with the rules of business concerned, has been making the appointment. However, it is equally clear that Article 324 has a unique background. The founding fathers clearly contemplated a law by Parliament and did not intend the executive exclusively calling the shot in the manner of appointment of the commission. This is what your lordships have found in the Constitution bench. 7 decades have passed by. Political dispensations are varying use, which have held the reign of power, have not unnaturally introduced a law. A law could not be one to perpetuate what is already permitted, namely appointment at an absolute and sole discretion of the executive. A law, as Mr. Gopal Singh Karnan pointed out, would have to be necessarily different. In the absence of such a law, does create a vacuum. This is despite the chorus of the voices, even cutting across the political divide, urging divesting of the exclusive executive of the appointment from the executive. We have noticed that the making of a law is ordinarily the power of the legislature. Lordship may exclude that. Come to 303. Political parties undoubtedly would appear to betray a special interest in not forthcoming the law. The reasons are not far to seek. There is a critically vital link between the independence of the Election Commission and the pursuit of power, a consolidation and perpetuation. As long as the party which is voted into power is concerned, there is not unnaturally a near insatiable quest to continue in this saddle. A pliable election commission an unfair and biased overshare of the fundamental exercise of adult franchisee, which lies at the heart of democracy, who obliges the power that be, perhaps offer the surest gateway to acquisition and retention of power. But what can be the more blunt way of putting it, my lord? That they have an interest. The values that animated of the freedom struggle has to be brought to the home by a new generation who has come to the inspiration relating to fundamental duties, criminalization of politics, a huge surge in the influence of money power, the role, and Lordship would, when it criminalization of politics, my lord, Lordship would note, my lord, 40% of our lawmakers, be it parliament, be it the state legislature, have criminal cases.
26.
And this court, my lord, despite taking various steps, my lord, have not been able to reduce that number.
Not the subject matter.
Yes.
It's confined to the subject.
Yes, my lord, very well, my lord, may I read it.
Tell us, after saying in various paragraphs the need
Yes, my
to
lord.
exclude the executive, why is it said in 315?
Yes. Yes, Lordship would sign the final name, Lord, in 320, para
The
326.
court is laying down norms.
Yes.
Laying down norms for what? Appointment of
Appointment of,
election
yes,
commissioner?
yes, my lord.
Why does court restrict it only for a particular period till the law is made?
The
The
till-
court could have stopped
till-
at 314.
Yes.
They are asking you, what was the reason that wait in the
No, because there was no law at that point of time.
There was no
Till a
law.
law is made.
There was no law.
Yes,
The
my lord.
court says that there is a necessity
Vacuum?
to bring in a law.
Yes, my lord.
The court is discussing, if you
Yes.
see Mr. Ansaria,
Yes, my lord.
309.
Please, your lordships. 309. In a unique provision of person, we are concerned with the devastating effect of continuing to leave the appointment in the sole hand of the executive or fundamental values as the fundamental rights, as we are also considered of the time the right for the court to lay down the norms. In other words, the vacuum exists on the basis of that unlike other appointments, it was intended all throughout the appointment exclusively by the executive was by mere transit or stopgap arrangement. It was to be replaced by a law made by the parliament, taking away. Now, the law is to be, my lord, taking away the exclusive power of the executive. My lord, this is what your lordship has said. Whether the law meets this test, whether the law has taken
Therefore,
over,
the court finds that it is high time that norms should be laid down.
and it should not be in the hands of the executive alone.
So then why is it said in 315?
315, my lord. That the law will be made, my lord. But law has to be, such law has,
You say that the basis of the order of
Yeah.
the judgment
yes.
has to be removed, which has not been removed.
No,
That is what we find
no,
from your.
yes, my lord. Basis
So
of,
this judgment on its bare reading
Yes.
shows that it was only to deal with a particular situation of a vacuum.
yes, my lord. And how the vacuum is to be filled, my lord?
So tell us.
Guidelines are
how do you
laid down.
extend it-
Please, my lord.
How do you extend it beyond
Yes.
the framing of the law?
Yes.
That this has to be the norm and
It,
the
my lord,
parliament
yeah,
has no
yes.
discretion.
No, parliament has the discretion so long as it does not live exclusively in the hand of the executive.
Your sheet anchor,
Sorry, my lord.
this judgment is your sheet anchor.
Yes, my lord.
It
Yeah.
says that Chief Justice should be there.
Yes. I'm not saying Chief Justice, my lord. There has to be, my lord. What I am saying is it cannot be with the hands of the executive exclusively. What the parliament does, my lord, there are various committee reports on various things. But it cannot be in the hands of the executive as Section 7 says. Section 7 says Prime Minister, a minister nominated by the Prime Minister and leader of opposition. Means, my lord, it is in the hands of the executive and executive alone. I'm not saying that lordship would issue a
We
mandamus.
have the parliamentary debates which.
Yes, I have, my lord. I will show to you, lord.
Let us go to that.
It is in that.
Because it stops at till the law is made by the
yes,
parliament.
yes, my lord.
So what did the parliament consider? How was this judgment considered by the parliament?
Please, lordship, would your lordship permit me to place that, my lord? Just, my lord. May I read just two more paragraphs and then come to the constituent and the parliamentary debates, my lord? para 301 and 3 by Justice, my Lord Justice Joseph. Yes. Yes. However, para 301, however, it is equally clear that 324 has a unique background. The founding fathers clearly contemplated a law and did not intend the executive exclusively calling the shots in the matter of appointment of so, my lord, the law which your lordships had declared, such law made by the parliament cannot be, which gives exclusive power to the executive. It does not meet the test of this judgment. It does not meet the test, the ratio laid down by this, which is called out from the Constituent Assembly debates and the various reports of the before and after the Constituent Assembly. And similarly, my Lord Justice Rastogi's view in para 353. Yes, yes. The Election Commission performs para
What
350.
was the final direction of the
Yes, my lord.
326.
lead opinion?
Yes, my lord.
Where do we find it?
326, my lord. Para 326.
326. Lead
Yes, Lord.
options are
Page 270, final relief. We declare, may I read that as per the appointment to the post of Chief Election Commissioner and Election Commissioner concerned, the same shall be done by the President on the advice tendered by a committee consisting of the Prime Minister, the Leader of Opposition in the Lok Sabha. In case there is no such leader, the leader of the largest single party in the opposition Lok Sabha having the largest number, this norm will, and the Chief Justice of India. This norm will continue to hold good till a law is made by the Parliament. As regards the relief of putting the placement of permanent secretariat, etc., not very important.
Still the law is made by the...
Till the law, my lord, I'm not saying that law cannot be made, but such a law cannot be made, my lord, in the teeth of the other findings, which says it cannot be exclusively in the hands of the executive. My grievance is there, my lord, that the constitutional makers, as well as this court in Anoop Baranwal has said, the appointment of the election commissioner or chief election commissioner cannot be in the hands of the executive alone. Now, whether this law, which has been made, has given the power to the executive completely, my lord, and it has, my lord, section 7 is, so it does not, my lord, satisfy the requirement of, my lord, the constitution or, my lord, as interpreted by our lordship, my lord, under the various paragraphs. And, my lord, what is the law now, my lord? What was earlier? Earlier it was, my lord, that the president makes on the aid and advice of the Council of Ministers. Now also, my lord, the president makes on the aid and advice of the Prime Minister and a minister chosen by the Prime Minister. There is no change in the position on the ground, my lord. The position remains the same.
Of opposition.
No, Mr. Sansaria, if you come back to the prayers once again.
Yes, my lord, may I just come back to...
Commanding the respondent to make a law.
Yes, my lord. Make a law ensuring free...
Ensuring so and so.
Ensuring so and so.
Ensuring so and so.
Yes. And further, my lord.
Does the Supreme Court have the power to say to Parliament, make a law?
No, my lord, it has not, and it has not.
But the prayer was direct Parliament to make a law.
But
in the first place,
yes,
was this prayer maintainable?
My lord, it was not granted, my lord. I will not say no mandamus can be issued to the Parliament, my lord. The law is very clear. There's no mandamus can be, it can be, some vacuum can be filled till a law is made, but that law has to be valid law. I cannot, that's like, my lord, in PUCL and ADR case, others case I've separate. The mandamus was till a law is made, you must declare criminal antecedents, your assets and liabilities. Law is made, you don't need to declare. And that was struck down in PUCL case. Only on the ground that the basis of the judgment, you cannot undo it by legislation, so-called legislation, by retaining the same position. Lord, here also, the position remains the same. Prior to making of the law, it was the president who makes on the aid and advice of the Council of Ministers. In other it, Lord, para 5.
To assist Mr. Hansaria, my lords, para 308 refers to the mandamus point.
308.
Yes, my lords. 308 and 309.
May I read, my lord, para 5. There are batch of petitions. In one of the prayer, para 5, in writ petition so and so for ADR, issue appropriate direction order directing, declaring the practice of appointment of Cji-Sc and EC solely by the executive is violative of 324 and Article 14, and that is what your lordship has done. And B, direct the respondent to implement an independent system of appointment of EC, etc., on the line of 255th report at Dinesh Goswami Committee report, etc., etc. And this is what your lordship has said. The various committees have said, my lord. Dinesh Goswami Committee report has said, the Law Commission report has said, my lord. It cannot be exclusively, my lord. Who can be? Parliament will take a call. But it cannot be, my lord, that the executive exclusively had it.
He answers the Mandamus.
308, would your lordship kindly see the para 308?
308 to 308. That's where the specific.
Yes, Lord, as your lordship has said, my lord.
Prerogative of the Parliament
Yes, my lord.
to enact the law.
Yes, my lord.
Courts cannot direct Parliament to make a law.
That prayer is rejected, my lord, in para 308, no doubt.
Now, for 7 decades,
Yes,
324(5)
yes,
was on paper only.
yes, my lord.
Court felt that it is high time
Yes,
that certain norms should be laid down,
yes.
and these norms should be followed till such time a law is made by the Parliament.
Please, your lordship.
Right? The court was conscious
Yes,
of its limitation.
yes, my lord.
So, these observations which have been made over 300 paragraphs,
My lord.
are these not to be read
Yes,
as justification for why these norms are prescribed till a law is framed?
my lord, till a law is framed, it is, my lord, these norms have to be followed. But when a law is framed,
When a law is framed, then can you say that these norms have been followed,
Lord,
have not been followed?
Lord,
Therefore, the law is
no. These norms flow from the constitutional mandate. Lord, these norms, which are laid down by your lordship, Lord, in various paragraphs, are derived from the constitutional mandate that it cannot be left to the executive alone. That is the mandate of your lordship's court. That if it is left to the executive alone, there is a reciprocity, there is no independence. So you have to have an election commission which is independent. And if you leave it to the executive, the independence is compromised. And if the present, my lord, if the present law which has been made, it is the same position, my lord. There is no difference whatsoever. There is no difference which has been there, my lord. The law which is made can be tested by our lordship, my lord, on the touchstone of Article 14 and my lord, and independence of election commission.
Very well. Proceed.
Yes, my lord. So, my lord, this is what has been held by your lordship, lord, that it cannot be in the executive alone, and then it is what has been done is by the executive alone. Para 353 only lordship may note it. Justice Rastogi in the concurring view said the same thing, my lord. Now, my lord, lordship may see the parliamentary debates. I have put the parliamentary debates in volume 2, my lord, on this bill. Which starts from page 108 of volume 2. Yeah.
Second volume.
Second volume, my lord. Yes. Page 108 starts. At 110, the law minister presents it, and at 111, Randeep Singh Surjewala, it is in Hindi, my lord. May I read it in Hindi, my lord? I have to read it slowly.
$111.
111, bro. Because the main opposition is by, my lord, speech is given by Randeep Singh Surjewala. It's in Hindi partly in English.
Well, will you read?
May I read it, my lord? सभापति महोदय, आदरणीय मंत्री जी ने कहा कि सुप्रीम कोर्ट ने कई निर्देश दिए हैं जिसकी चर्चा बाद में करेंगे। ठीक है, चुनाव आयोग को आधार प्रजातंत्र की शुचिता, प्रजातंत्र की निष्पक्षता है। संविधान डेमोक्रेसी जिसको हम प्रजातंत्र कहते हैं, उसका आधार ही निष्पक्ष चुनाव और निष्पक्ष चुनाव कराने वाली एजेंसी चुनाव आयोग है। आप जब भी आप चुनाव आयोग की बात करेंगे तो ये 4 शब्द निष्पक्षता, निर्भीकता, स्वायत्तता, शुचिता आपके जेहन में जरूर आएगी। सर, आप सभापति जी हैं और कानूनविद के तौर पर सुप्रीम कोर्ट के एक काबिल वकील भी हैं। 140 करोड़ लोगों के इस देश में किसी व्यक्ति के जेहन में ये 4 शब्द आएंगे। ये कानून है आज माननीय मंत्री जी और सरकार लेकर आई 4 शब्दों को बुलडोजर करके बुलडोजर के नीचे कुचलने वाला कानून है। ये मेरा विनम्र आग्रह है। सभापति, इसके पहले मैं भी इसके प्रधान कर चर्चा करूं। इंडिपेंडेंस ऑफ इलेक्शन, जिसे अंग्रेजी में कहते हैं अवॉइडेंस ऑफ इंटरफेरेंस ऑफ एग्जीक्यूटिव, हमारी इलेक्शन मशीनरी इन दोनों बातों से प्रेरित होगी। ये हमारे संविधान के निर्माताओं ने कहा था। काश आदरणीय कानून मंत्री जी मेरे, आपके और इस देश के लोगों के नहीं, बल्कि जो बाबा साहब अम्बेडकर ने कहा था और संविधान सभा में जो चर्चा हुई थी उस पर एक नजर डाल लेते तो शायद ये कानून को अभी तक वापस ले लेते या बनाते ही नहीं अथवा लेकर ही नहीं आते। माय लॉर्ड, and sanctity. निष्पक्षता, इंडिपेंडेंस, निर्विकता, okay, independence and sanctity. Now, Hindi word is निष्पक्षता, निर्भीकता, निर्भीकता,
Nirbhikta means fearless.
fearless. I'm so sorry. Fearless, स्वायत्तता,
Independence and sanctity.
and suchita.
Sanctity. Independence and sanctity.
Yes. Now, would your lordship kindly come to my lord, page 114. Again, Mr. Surjewala, yes, it violates and negates the rigors and affirmation by the Constituent Assembly by Baba Saheb Ambedkar and other individual honorable members of the Constitution. It goes against the very spirit of the Constitution that it enriched in Article 14. It completely negates and subjugates the Election Commission to the authority of the executive. It does away with, and I respectfully say willingly, and if I say maliciously, the judgment of the Supreme Court in toto. That is why the law is per se like stillborn child. Thirdly, I want to point out, जैसा माननीय उच्च न्यायालय ने कहा, आर्टिकल 14 जो हमारे मौलिक अधिकार का हिस्सा है, जो सत्ता में बैठे हुए सत्ताधीशों के बेलगाम कार्यों पर अंकुश लगाने का सबसे बड़ा तरीका है, यह आर्बिट्रेरी पावर। यह पूरा कानून उस आर्टिकल 14 के लेटर इन स्पिरिट के विरुद्ध है, इसके मौलिक अधिकारों का उल्लंघन है। जैसा माननीय उच्च न्यायालय ने कहा, सभापति जी, अपॉइंटमेंट कमेटी है, अब एक एम्प्टी फॉर्मेलिटी है। इफ आई कैन यूज द वर्ड अपॉइंटमेंट कमेटी, क्या है? माननीय प्रधानमंत्री जी और माननीय प्रधानमंत्री के मनोनीत किए गए और उनके एक मंत्री हैं। गांव की एक कहावत है, क्योंकि ग्रामीण पृष्ठभूमि से हूं और आप भी हैं, आधा बांटे रेवड़ी मुंह